फिर वो question of maintainability will also cut you.
No, sir. The thing is, as far as their locus standi is concerned, there are two judgments of statutory bodies.
Locus standi, simple सी बात है ना. Locus standi is a different thing from capacity. Their local standi, from what I can understand, is they have passed an order. There's right or wrong is a different thing. We don't want to go there. And they say if we have to ensure our orders are abided by, unless set aside by a law of a competent forum. So all they are doing is ensuring that even if it's an illegal order, let's not get bogged down in that debate. If they just give up, then the orders will be rendered meaningless.
Then a party, affected party, which brought the matter before the election commission, has the locus standi to file, but not the election commission.
Like for example, affected party can inform the election commission for whatever reason. The election commission may act on its own. Election commission may act on the information of a person. But now that they've passed an order, they're not entitled to defend their own order and surrender.
That's what I'm submitting.
Yes, on what basis?
Kindly see the case of a district judge. He passes an order. That order is challenged before the High Court. High Court sets that aside. Can the district judge come before the Supreme Court that in defense of his own order? No, it's a judicial body.
There is a slight difference, not a slight difference, a major constitutional difference would arise. The district judge falls under the hierarchy of courts to be supervised and controlled by the High Court under Article, I don't know, what is it, Makhdoom?
Whatever it is. I'm just giving an example.
No, example लगेगा नहीं. Now this is a separate body. You cannot apply that argument. The separate body, I've given you the example of Collector of Customs. Every day they are filing before us. Collector of Customs appeals. His own order is come and it's been turned upside down by the High Court. So he comes before us. We hear him. Nobody's ever raised an objection that they can't be heard.
There are two cases recently in which this Honorable Court has held.
बताएं कौन से? Which are those two cases?
Yes, those two cases. The recent one is 2023.
PLD?
PLD 2023, Supreme Court, page 516.
And the other one?
And the other judgment, where the Ombudsman has...
other judgment, yes.
The other judgment is PLD 2020. 2020. Supreme Court 586.
What was the facts of the first case?
They have held...
The first case, बताइए, let's go to 516. What is the ratio in that case?
Yes, they held the order which was passed by Commissioner and was challenged subsequently before the High Court, before the Appellate Forum and High Court.
Which Commissioner?
That the Commissioner cannot come.
The Commissioner, Election Commission?
Yes, not the Election Commission. In that case, it was Competition Commission.
Gee.
But there is a clear judgment.
Okay. So how is it? No, let's finish with one judgment at a time. How is this judgment applicable to a constitutional body?
Sir, kindly see para 23, page 535. Why I'm putting this before this Honorable Court?
Please.
The whole exercise may be unnecessary.
No, let's read it. To be honest, I've not read it, so let's read it. You may well be right.
Page 23. It may also be petitioner to mention here that KNN's food which may have been aggrieved of the decision of the tribunal on the point of non-applicability the provisions of section 10(2)(a) of the Act has been impugned the decision of the tribunal by preferring an appeal to this court, and it is the Commission that has challenged the decision of the tribunal on that point by filing the appeal. In this regard, we may observe, though the role of the Commission under the Act is primarily of a regulatory body, it is a quasi-judicial, as well as some provision, as well under the same provisions of the Act. The provisions of clauses A and D of Section 10(2) of the Act, in our view, envisages the quasi-judicial role of the Commission while declaring upon the divergent claims and allegations of two competing undertakings. And as held by this court in Wahaki Motasib's case, an adjudicatory body deciding a matter in the exercise of a quasi-judicial powers between two rival parties under a law cannot be treated as an aggrieved person if its decision is set aside or modified by higher court under the law or by a court of
Are you equating a quasi-judicial body with a constitutional body?
Sir, statutory body.
Are you? I don't know what your answer is.
So
first say yes, no, then you
is a distinction between a statutory and a constitutional body. They are all under the law, under the fundamental law.
No, not at all. A constitutional body functions under the Constitution.
Yes.
A statutory body is a sub-constitutional body functioning under a statute. So are you equating the two?
Sir, rules, the certain principles are equally applicable to statutory as well as the constitutional body. If the principle is that a body is vested with quasi-judicial powers, it exercises a quasi-judicial power, passes an order between the parties.
I would call it a constitutional power. The Constitution grants, we don't make this Constitution, we only interpret the Constitution. And I don't want to read words into the Constitution either. The Constitution, in its wisdom, the Constitution makers created a separate constitutional body.
Yes.
Now, you may well be right, and I may agree with you 100% that a statutory body which determines a matter should not file an appeal. However, it will raise the questions how a collector of customs, etc., are filing appeals. But that matter is not before us, so we will not dilate on it. Can you show us a decision where a constitutional body, preferably the Election Commission of Pakistan, the same principle has been enunciated by this court?
Sir, actually, the principle is enunciated here as well as in another case of 2020, where ombudsman.
Ombudsman is also a statutory body.
Sir, what they are relying upon is the statute and provisions of the statute. Sir, for all intents and purposes, they are acting under the Election Act, and that is a statute.
Ansab, this will amount to virtually finishing off a constitutional body.
Sir,
one thing is you are now on a very technical, hyper-technical argument, for which you have no precedent. The two precedents that you have filed, I'm just thinking aloud, apply to statutory bodies. Here we're dealing with a constitutional body. A constitutional body is altogether different from a statutory body. If a constitutional body feels aggrieved, either you let the constitutional body do its work. Probably they will argue that why is the High Court interfering in the work of a constitutional body? Unless it's something blatantly unconstitutional, I don't know. Whether the forum would be the High Court or the Supreme Court, I don't know. I'm just raising the questions as they come to my mind. But please don't equate a statutory body with a constitutional body. I will not do so.
Sir, the two bodies.
So मैं आपको हामिद खान एक आया था, मैं आपको बताता हूँ. I was sitting with former Chief Justice Jawad Khwaja. The matter came for holding of local government elections. The Supreme Court had passed a number of orders extending the dates, and Jawad and some, let's say, valid reasons were given for extending the dates. And I leaned over to Jawad Khwaja Sahab, and he was about to do so, and I told him, I will write a dissent. He says, why? I said, that's a constitutional body. How will I direct it to do so? It's their job. And he said, oh, you got a point. And we did not. We said, this is their job. Do your job. We can call upon you to do your job, but we cannot take on the functions of the constitutional body. There's a very clear line of demarcation. So if they're not doing their job, or they're doing their job unconstitutionally or contrary to the law, yes. But if they're doing their job, we won't take over their job, how to do it, how better to do it. I don't know. Because then every judge will start running a constitutional body.
Constitutional body performing functions under a statute. The whole controversy is arising after that statute, which they are relying upon with the Election Act. So in this case, while exercising powers under the statute, it is a statutory body for all intents and purposes.
चलिए हमने आपका objection note कर लिया. ये बताइए, do you have an exact case on the point of the Election Commission of Pakistan? Because yes, we will consider these submissions, but if you have an actual case, you will further clarify the matter.
The two cases are recent.
वो हमने देख लिया. One is ombudsman, which is set up under some federal law. The other is the case of the Competition Commission, which has also been set up under
1983
statute. But you can reserve it. You don't have to respond. So you can continue bolstering your argument when we give you an opportunity. We've heard your original objection. It is not something which immediately appeals to me.
Okay.
I mean, but having said that, I'm open to persuasion. So is that fair enough?
Yes.
So shall we let Mr. Makhdoom Ali? No, shall we let him proceed on facts? And wherever a fact, not the law or his interpretation is wrong, please let us know that this is factually wrong. So let's make some progress.
After completion of arguments, and still reserve the right to take this objection.
By all means. By all means. I mean.